Good evening and welcome to this very special edition of the India Development Debate Direct. We are in conversation with the man who will go down in history to get India's privacy law in place. Justice Srikrishna joins us on the latest moves here in New Delhi that many people believe allude to a snooping sarkar, that many people believe, can be done without the Parliament's approval. But thank you very much, Justice Srikrishna, to answer some of our very important questions. And the first question obviously has to be first the social media surveillance hub, then the blanket permission to 10 agencies to snoop and, intercept our computer resources, and now a draft to change Section 79 of the IT Act. Well, it's all being done with a declared view to curb misuse of social media platforms and fake news. At least that's what the government seems to be suggesting here. But isn't this once again an instance of government seeking data on users? And the question really is, how worried should one be, especially in the absence of a data privacy law?
Supriya, first let me confess that I haven't read the draft that has been put in the public domain. I have just got the impression from reading the newspapers. Now, what has happened is, irrespective of the Data Privacy Act, which is yet to come into force, in the sense the bill is yet to be passed, privacy or the right to privacy has been declared to be a fundamental right, thanks to the Supreme Court's judgment, which means that it can only be subjected to a restriction in the manner that the Constitution envisages. What does the Constitution says? Constitution says that a fundamental right cannot be curbed except by a law made by Parliament. Please note this, any amount of executive action is not sufficient to curb a fundamental right. And number two, it has to be for a declared objective as to why are you doing this, and that objective must be seen in the act itself. Number three, that it cannot be disproportionate to the objective that is sought to be achieved. Now, you cannot, if you want to swat a fly, you take a fly swatter, you don't take an atomic bomb and throw it on the fly. Similarly, the constitutional requirement is that you thus far and no further. Now, if by an executive fiat, by amending the rules, which is not law made by Parliament, if the fundamental right to privacy is being curbed, I am sure some court will declare it to be unconstitutional. I read in the newspaper this morning that someone has already challenged it in the Supreme Court. Let's see what the Supreme Court says about it.
No, I know what you're saying there, Justice Srikrishna, but while the Supreme Court has declared privacy as a fundamental right, it did also say that public interest and national security are some of the restrictions that are going to bind this, and this is not going to be absolute. Do you believe that the point, this particular point, the factors that restrict it, whether it's national security, public interest, are being used by the government to make a move which many, including myself, believe it's disproportionate to the declared objectives?
Even assuming that the government is using the leeway, the act has to be passed by Parliament. Please note that there is no parliamentary enactment as of today giving this kind of a right. And in any case, while discussing the Data Protection Act, also the committee had suggested that yes, in the interest of the state's security, in the interest of investigation of crime, in the interest of curbing terrorist activity, it may be necessary for the state to take data of the citizens without their consent, but subject only to the safeguards to be enacted by a parliamentary enactment, without which you cannot do. What is the advantage of a parliamentary enactment? The parliamentary enactment, in order to be constitutionally valid, must have the three elements which I already told you. Apart from that, it must also indicate a detailed procedure. Who can do it? Not every constable can do it. At what level? For what purpose? What is the procedural safeguard for that? Should there be some kind of a judicial oversight on that? All this has to be carefully considered by Parliament. You just cannot pass an executive fiat and say from tomorrow I'll snoop into everybody's line or telephone line, or for the matter into the internet connection.
Oh yeah, absolutely. I don't think anybody and everybody can be accessing data, because that is what data privacy is going to amount to and is all about. But sir, the latest proposed changes clearly doesn't need a parliamentary approval, is what people here in New Delhi and at least in the Ministry of Electronics and IT are saying, and that is what is worrying a lot of people, that how is this bypassing parliament? I know you've alluded to this, but you know, this clearly seems to be bypassing parliament, even though you believe that parliament alone can stipulate a law which is in contravention to the data privacy law passed by the Supreme Court.
If it does, then I can assure you that it will be unconstitutional. I am sure some court in this country will hold it to be unconstitutional. Because that is the first requirement of curbing a fundamental right, infringing upon a fundamental right. This has been laid down long ago, and the Supreme Court has consistently continued with this view.
No, Justice Srikrishna, I do want to get into some of the specifics of what is being tried to done. Some of the amendments, therefore, include asking sites to deploy technology to proactively identify and remove harmful content. Now, this was not being done. So far, the government or the courts were telling them, and then only was, content being removed. The ISPs are also being empowered to remove it. Breaking of end-to-end encryption is being suggested to trace origin of message, and a 72-hour timeline within which companies have to reply to any government query. Now, presuming that government obviously has WhatsApp on top of its mind when it's looking at these things, but this is going to affect every online platform that operates in India so far. I mean, like I said, so far they haven't done it at their own free will. They haven't been proactively, because of some technology tool and algorithms, they haven't been able to remove content at will. Are we giving them the freedom to do so?
Very well. IT Act was intended for a different purpose. The objective of the IT Act was something else. Now, at that stage when the IT Act was passed, right to privacy had not been determined to be a fundamental right. That makes a sea change in the situation. IT Act, whatever its vintage, today cannot stand against the fundamental right declared to right to privacy, which the Supreme Court has declared in Puttaswamy's case. Now, if that is so, then all the constitutional parameters have to be met with before any infringement, any curbing of the fundamental right to privacy can come about. It cannot come about by an amendment to the rules. If somebody has advised the government, I am afraid they have barked up the wrong tree.
No, absolutely. But so you're essentially saying that changes being proposed to the IT Act are opposing the Supreme Court ruling on fundamental right to privacy, and which is why the government perhaps needs to go back to the drawing board, and Parliament alone can change this. I'm just trying to reassert and, just for the benefit of our viewers, get that straight.
I agree with you. Just because an act is already, look, as far as the constitutional amendment, constitutional position is concerned, whether the act was passed before the judgment was pronounced or it is passed after the judgment is pronounced, it has to meet with the constitutional requirements. So, perhaps it is possible that several of the sections of the IT Act may be challenged on the ground of fundamental right to privacy, which was some far way ahead of what happened in that Singhals case. You remember that section 65A was struck down as unconstitutional. Now it can be a much wider canvas on which there could be a lot of challenges.
So one of the points that I do want to touch upon is, and that's a sense I have, and you can correct me if I'm wrong, instead of limiting data these sites collect from us or reviewing their usage, the government here seems to want to collect more and more data for itself, it seems. Am I too off the mark? I mean, do you not get a similar sort of a sense as well?
Yes, so to that extent, that would have been taken care of had the Data Privacy Act brought into effect. That has not still come into force, because I don't know whether they have introduced the bill also. I am not sure whether the bill has been introduced in Parliament. There is a lot of back and forth going on that. There is a lot of lobbying by the foreign companies with regard to localization of data. All that is yet in a stage of consideration. But if that act comes into force, then they cannot do this kind of a backdoor entry into the situation of curbing any of this. The government would not be entitled to collect any data of the citizens unless it is warranted by an act of Parliament, that too in a manner contemplated by the Constitution as indicated in Puttaswamy judgment.
No, fair point indeed. Justice Sri Krishna, there's also no denying, and just to be the devil's advocate for a minute, there is no denying that online platforms are problematic and they need a fix. But how does one balance between safeguarding privacy on one hand and tackling fake news and preserving our fundamental rights of speech on the other?
Therefore, I told you, all these four parameters have to be applied. So, take one by one. What is it that you want to do? You have to declare an object. Control internet, for what purpose? What is the objective to be achieved? Only to curb harmful content. Very well. How do you propose to go about it? Does the act have any mechanism by which only harmful content can be curbed? Now, if that is so, make sure that the act does not step even 1 millimeter beyond that. And finally, what is the procedural safeguard? How have you ensured that the act does not impinge on the fundamental right of privacy under the garb of curbing harmful content on the internet? Therefore, there has to be a procedural safeguard. Who can authorize it? Under what procedure? What is the pre or the post sanction procedural safeguard? All this has to be built into the law. Otherwise, the law is open card for disaster.
I kind of agree with you, sir, but I think, I don't think any of us will oppose what is being done on the name of security, or, we would want our national security to be preserved. But somehow the sense that one gets is that national security is a very loose bogey that's being used. It's being sold very loosely, move after move, to impinge upon data privacy, unapologetically to impinge upon our fundamental rights. This whole bogey of security is being very loosely sold right now.
Possible. If you have noticed, that's what happens all over the world. More and more states want to take power into their hand and ensure that in the name, this is a trump card they will always use, state security. That is why if there is a properly debated parliamentary enactment, then the parliamentary enactment will consider this, saying that all right, if you have grounds to say that this content is harmful because it is of reasons A, B, C, then only you can do it. Who will be authorized it? Somebody very high up in the hierarchy, or even a judicial oversight will be there. And after you have done it, it will be subject to challenge on these grounds. All that has to be done. Otherwise, it will be giving a loaded gun in the hands of people who don't know how to use it.
Oh, absolutely.
Oh, no, forget about how to use it. I think you'll have a lot of people who are going to exploit it. I mean, people who have exploited it in the past. So, we are perhaps going to see all of that as well. But you were saying something. Go ahead, sir.
I just want to explain this to you a little more. Now, for example, I have no criminal background. I am not a terrorist, or nor do I support terrorist activities. But yet, somebody may, without having to declare why he wants to do it, tap my telephone, my internet, my computer connection, snoop into my computer. Now, that cannot be tolerated at any cost. Now, if there is some material which is originating from my computer, which indicates that I am supporting a terrorist activity or criminal activity or leaking out military secrets, very well, then you have to record these reasons, go right up to the hierarchy, to the topmost person that is possible, take action only under those circumstances. Otherwise, it will be police raj and nothing else.
Point, absolutely fair point. We can't afford a police raj in the country, but just to be the devil's advocate, the government says and insists that law enforcement agencies monitor the net without proper legal template and code in place, and this will perhaps put the required framework. This will perhaps put the required norms in place.
That argument has no basis whatsoever. Yes, I agree. Today, what is being done is there is a lot of snooping done without a warrant of law. What is that law? The law must be a specific law passed by Parliament, either generally allowing this kind of snooping, or specifically saying in these circumstances only for this purpose you can do the snooping. Now, there is no such law today also. So, how can you say that this is, I would say it's only a fig leaf.
While Justice Srikrishna, I do cherish my privacy and my fundamental right to speak what I want to very dearly. But I also am someone who wants to ensure free and fair elections. Now, in this age of fake news menace, how does one ensure that? Because there is just so much of narrative that's happening otherwise, which is obviously all fake news. How does this one ensure free and fair elections in this age of fake news?
Supriya, recently I was invited to deliver a keynote on a seminar which went into this question of fake news. Now, what is fake news? Fake news is usually half-truth intended to deceive. Please notice that it is not intended to disseminate news, and it is not totally false. If it is totally false, nobody will believe you. Therefore, it is partial truth disguised as 100% truth and then disseminated with the intent to deceive people. Now, I am sure there are, and so I was advocating that some judge should be bold enough to say that this is something that falls within the mischief of the IPC itself, causing harm to somebody, causing gain to somebody, or just plain mischief. Somebody should try it out and say, even before the law is actually properly put in the template, that somebody should take the bold step and say this should be curbed. If nothing else, I am sure one of the high courts can exercise their power under Article 226, which is as wide can be.
I do hope one of the high courts are going to do that, because the menace of fake news is terrible. I mean, look at the kind of stuff that you receive on your WhatsApp or on your Facebook posts and all of that. But a last quick question, and you've presented the draft for the privacy bill. Do you believe Parliament and our lawmakers are kind of sidestepping the Data Privacy Act and are moving ahead with some of the things that we've just discussed? Because that needs to be dealt with at an urgent level in Parliament, and that's not happening.
I don't know. I am not sure of what the parliamentary calendar is, and I don't know. Probably they have very important issues to consider. This may not be of such a great priority to them. That is the best I can say.
Okay. I don't know what is more priority than safeguarding the privacy of our people. In any case, hopefully Parliament, when it convenes tomorrow, will find some solutions to that. But thank you very much, Justice Srikrishna, for being with us right here on ET Now. He is the original architect of the Data Privacy Act. He submitted his draft, and now the government and the opposition need to get together and implement that as law. Hopefully Parliament will see to that, because data security is important, so is national security. But nothing should be done at the behest of fundamental rights, and of course the Supreme Court's ruling that privacy is indeed a fundamental right. Thank you very much for being with us. We take a quick breather. There's plenty more that's coming up right here on ET Now. Stay with us.